Yes, Mr. Watkinson.
May it please your lordships, in my submission, the Upper Tribunal.
Sorry. I'm so sorry.
Give me, my lord. In my submission, the Upper Tribunal is correct in the conclusions it reached, my lord, and for the reasons it gave.
Yes.
And in summary, I will make the following 5 submissions, which I'll seek to expand upon with my lord's leave. That firstly, there is no inalienable right to deduct input tax.
Right of deduction?
No inalienable right of deduction. So the initial exercise of the right to deduct and the later proof of it are separate issues. And once the National Fiscal Authority has required the production of the original VAT invoices as proof, of the right to deduct, and that's not being complied with, the right to deduct can, in principle, be refused. The taxpayer cannot simply rely on an earlier holding of the VAT. The second submission then, my lord, is once that event has taken place, so the tax authorities required the invoices to be produced, and they have not. Even if that is all that has happened, and even if the appellant is correct that the Regulation 29(2) discretions are somehow not engaged, the jurisdiction on any appeal to the FTT against the consequent refusal of the right to deduct is supervisory only.
And this submission is concerned only with a case where invoices have not been produced.
But they've not been produced at all. Thirdly, my lord, the alternative evidence discretions in Regulation 29(2) are engaged whenever the requirement to produce the valid VAT invoice is not complied with. And that is whatever the stated reason for the non-production, and whatever the true or proven reason for their non-production. So in other words, my lord, the precise way in which the taxpayer chooses to answer the requirement to produce valid VAT invoices cannot control whether the discretions are engaged. Fourthly, my Lord, and it's not in dispute, once the alternative evidence discretions are engaged, the FTT's jurisdiction on the appeal is supervisory only. Fifthly, my Lord, whether HMRC have notified an assessment under Section 73 of VATA or simply denied the input tax prior to it being credited or repaid, cannot change the nature of the FTT's jurisdiction. Remains the same in either case. So for the first submission, my Lord, inalienable right, I rely firstly on Reisdorf and secondly on paragraph 4.1 of Schedule 11 to VATA. Can I invite my Lords to turn up Reisdorf briefly, please? I hope it's in tab 5 of your first bundle of authorities, beginning at page 84. As my Lord Justice Miles already noted in argument, this was a case where the taxpayer did not produce the relevant invoices to the German authorities, despite claiming to be in a position to do so. Have my Lord Advocate General Fennelly's opinion. Can I ask you to pick that up at page 90, please? Paragraph 18, just below F. Final sentence. The possibility of dispensing with production of the original is a separate matter, more relevant to the second and third questions, and must be clearly distinguished, as it is by the National Court, from the first issue of principle.
The questions to which they're referring are at paragraph 11, aren't they?
They are, my Lord.
So we can
So,
see what the sequence is.
And it's really question 2 that's the most pertinent.
it is, my Lord. And so this is the Advocate General, as we'll see, follows on into the Court's judgment in my submission, noting that the principles concerning initial deduction are different from later proof thereof. One then goes on to page 92, please. Paragraph 26.
Now, just before we go there,
Give me mine.
the heading at 91 shows that we are now in his analysis of questions 2 and 3.
Yes, we are, forgive me. We're now in 2 and 3. Paragraph 26, between F and G. Advocate General Fennelly accepts the plaintiff's and Germany's position that the right to deduct cannot be subject to the ability of the taxable person to present the original invoice in circumstances where he's able to produce other probative invoice in accordance with the rules laid down by the national authorities. So that is the discretion. then over the page, 93, A to B, the Advocate General's opinion that it would be perfectly reasonable for national fiscal authorities to take the view that a taxable person who simply refuses to produce his invoice or ticket of admission should be deprived of the deduction. And thereafter, and ultimately, in the final sentence there, the decision as to whether to require the production of that invoice should, in my view, be left to the member states. One then goes into the judgment, please. Beginning at page 96, paragraph 19, please. The Court made the point that it's necessary to distinguish the provisions of the directive relating to exercise of the right to deduct from those concerning proof of that right after a taxable person has exercised it, saying that the distinction between the two is inherent in the operation of the VAT system. On my learned friend's submissions, that distinction does not exist. They're elided. The Court firstly then deals at paragraph 20 with exercising the right to deduct by holding an invoice. And noting paragraph 23, the power given to the member states to set down criteria determining whether documents other than the original invoice may serve as an invoice. 24, that power is consistent with one of the aims of the then 6th directive, ensuring that VAT is levied and collected under the supervision of the tax authority. The second concept with which the Court is dealing with is then picked up at page 97, please. Paragraph 26. That is dealing with proof of the right to deduct input tax after it's been exercised. The Court refers at 27 to what was then Article 22.2 of the 6th VAT Directive, the record keeping. Then at paragraph 29, says that it follows from those provisions that the 6th Directive gives Member States the power to determine the rules relating to supervision of the exercise of the right to deduct input tax, in particular the manner in which taxable persons are to establish that right. And as my Lord said in argument with Mr. Brown, a learned friend, Court here endorses paragraphs 26 and 27 of what Advocate General Fennelly said. So firstly, that one can require production of the original invoice, and if it's not, it's perfectly reasonable to refuse the right to deduct. And then ultimately, it is for the member states to supervise the rules governing proof.
It's at least to me, it's a strange use of language, and it's probably because of where it comes from. But if we could just look for a moment at Articles 168 and 178, which I think underlie this, don't they?
Yes, my Lord.
And 168 is at 48.
Yes, my Lord.
At least in my, yes, 48. And so the way it's, is this the root provision for deduction?
So this is the right to deduction, my Lord.
Yes, but
basic right.
Well, the way it's put is that insofar as the goods and services are used for the purposes, etc.
Yes.
Which is, of course, what the tax authorities are seeking to verify.
But they're seeking to establish that there's been a taxable supply to the person
Yes.
who is seeking to
Well,
deduct.
so that at the beginning of 168, there's this clause, and then it goes on, the taxable person shall be entitled to deduct. Right, so that's where it starts with. And that then becomes in 178, which is at what, 52, is then described as the right of deduction. And in order to exercise the right of deduction, the taxable person must meet the following conditions.
Yes.
So it's a right that is, as it were, conditional in one sense, that it's got to relate to a taxable supply.
Yes, my lord.
168. It's also conditional in its exercise, in that you have to meet following conditions and so forth, which are then elaborated in national law.
Yes.
But so expressions such as, I have the right to do something, or I refuse your right to do something. And essentially what you're doing is you're presenting to the tax authorities what you say are your deductibles. And they're saying whether they accept them or not.
Effectively, yes.
So, I mean, it doesn't fall, at least in my mind at the moment, with some other forms of rights with which we're used to dealing in other contexts. Because, I mean, the right to deduct is a right to deduct where you, A, have a supply that qualifies, and B, follow whatever the rules are that
Yes,
bring you home in its exercise.
So you have a taxable supply, and ordinarily you hold a VAT invoice that's valid.
Yes.
Those are the preconditions to
Yes, but I'm
and the exercise.
interrupting you at this point because you're dealing with concepts of inalienable right and so forth. But it's a particular form of right, if it's a right.
Yes, it's a right as opposed to a duty, my lord. So there's no duty to deduct input tax. You don't have to, but if you want to, you need to satisfy the conditions for the right itself to arise, and you need to satisfy the conditions to exercise it. And the second part of that involves ordinarily holding a valid VAT invoice. The third stage is then, what if the national fiscal authorities require proof of the first two? They ask you to produce the invoice, and if you don't, they refuse you the right to deduct because you haven't established that you could exercise it. So, might I return to Rysdorf, my lord?
Yeah.
I'm great. So the ultimate conclusion of Rysdorf back at page 97. Paragraph 29, the court held that the power conferred on member states includes the power, so it's not exhaustive, has the power to require production of the original invoice, and the power, where they don't hold it, to allow him to produce other cogent evidence.
Yeah.
And at 30, in the absence of specific rules governing proof of the right to deduct, it's the same point. And in effect, it is left to the member states. And so the first proposition I draw from Rysdorf is that as a matter of principle, where a taxpayer refuses to produce a VAT invoice when required, the right to deduction can be refused. It follows from that there is no inalienable right to deduct input tax at a European case law level. And that is then reflected in the domestic legislation. Because in my submission, paragraph 4.1 of Schedule 11 to VATA is a clear and unambiguous statutory provision reflecting that power.
This case that we're looking at is ultimately about the proper interpretation of Article 18 and the words hold the invoice.
Yes.
The court seems to answer that by saying that the concept of holding the invoice includes, depending on the national law, an obligation to provide it, because it's the court's answer to question 2 is that the courts can, sorry, that the authorities, depending on the national law, can require production.
Yes.
And they seem to say that that's part of the concept of holding, because that's the word which is used.
Yes, it's part of holding looked at through the lens of also the requirement for you to keep adequate accounting records to enable inspection. The ultimate end point of that is you need to be able to produce it to the authorities
So
when they ask.
Putting it another way, there's not much point in, there wouldn't be much point in just having a regime where the taxpayer could just hold the thing in the sense of putting it in a safe.
It would mean
producing it.
It would
And
mean
so they're
that
giving it a
point of right.
purposive interpretation.
Yes.
And it could be argued, could it, that I don't know whether this informs then Regulation 29, because that uses the same term. It says at the time of claiming deduction of input tax in accordance with paragraph 1, the person shall hold the document which is required to be provided under Regulation 13. Is it part of your submission that the concept of hold should be given a similar sort of interpretation as is given to that term in Reistorf?
My submission is it doesn't have to go that far because of Regulation 29(2), which includes the power to require provision, and it doesn't have to go that far because of Schedule 11, paragraph 4.1, which gives the revenue the power to require production for the purpose of permitting input tax. And so my submission is I don't need to go that far.
Right.
And the domestic legislation implementing the requirements here have holding at one level of Regulation 29(2), but at the next level, that is tied in with the paragraph 4.1 Schedule 11 power to require production.
Yeah.
So it is not, as my learned friend would have it, as soon as I get through the gateway of holding, the Regulation 29(2) discretions just fall away, because they require something more. You can say, as the revenue, I need you to provide. So it cannot be that one draws a bright line between the two parts of Regulation 29(2) in terms of considering their structure, in my submission.
In paragraph 30 of Reistorf, you were referring to the purposive part of this, that it's in the third line, in order to establish that right. So however one describes the sort of right that you have when you're VAT registered and you've got an invoice, they're contemplating something in order to establish it.
Yes, they are, my lord, and that's because if it were otherwise, almost as adverted to by my Lord Justice Miles, that the revenue in any country governed by the principal VAT directives are incapable of policing it. Someone will say, well, I hold the invoice. Effectively, go away. I have the right to deduct.
I mean, for example, I know the danger of analogies and so forth. I already referred to one, but I mean, you may have a right to citizenship of a certain country because you were born there, or your parent was born there, or even your grandparent was born there. But you still have to take steps to establish that right. You may have that right, but you have to take steps to establish it.
Effectively, yes. And whilst, of course, this is a different context, it's the same system. You need to establish your right, and the primary way of the revenue checking that is the statutory power given to them to require production on pains that if you don't, they may refuse your right to deduct.
Yeah.
And so, as the Upper Tribunal found, and in my submission, which is not disputed, that's the requirement HMRC imposed here, produce the invoices. That requirement was not met. So as a first step, the input tax deduction is refused, and it must be, in my submission, for the statutory scheme to have any cogency, that the para 4.1 Schedule 11 VATA power overrides any earlier purported exercise of the right to deduct. If it were otherwise, and this right is inalienable, then the purpose is meaningless. That provision has no function. And that would run directly contrary to what Advocate General Fennelly and the court said in Reisdorf about the supervision of the VAT system being for the authorities and that being one of the aims of the system. So in my submission, the Upper Tribunal was correct at paragraph 108 to rely on paragraph 4.1 of Schedule 11. And further, as is clear from Reisdorf, the issue of the initial exercise of the right to deduction and later proof are conceptually separate. Yeah. My learned friend's submission elides them. And so the first stage of the analysis in my submission, my lord, is there is no inalienable right. The next stage is what happens where HMRC have imposed that discretionary requirement and it's not being complied with.
This is your point 2, is it?
This is point 2 that I'm moving on to.
Yeah.
The appellant submits that it must be full appellate, but offers in my submission no cogent reasoning as to why that must be the case. In principle, it's based again on this notion of an inalienable right to deduct. So there are 3 bases for the second submission. That is that this is a supervisory jurisdiction only. Firstly, what the court said in Petroma about the effect of providing information after a decision has been made to deny the right to deduct. Secondly, the general principles of administrative law in cases where challenges are made to discretions exercised by a public authority. And thirdly, those same principles where they concern impugning decisions by reference to material that was not put before the decision maker. Those are addressed in the trio of cases I've cited in the skeleton argument: Cottonzad, Boyce and Scandico, but beginning with Petroma, if I might please, which I don't think you've been taken to. But can I invite the court to turn up Petroma, should be in your first bundle of authorities, my lord, tab 7, beginning at page 113.
Yeah.
And what had happened in Petroma was that the tax authorities had carried out some inspections. The taxpayer had produced incomplete intercompany invoices which couldn't be shown to correspond to actual services. They then denied the deductions for non-compliance with domestic provisions as to the invoicing requirement. And then after that decision, the taxpayer provided additional information which was not accepted as sufficient. It's a summary of paragraphs 12 through to 14. Can I invite anyone to pick up the judgment at page 118, paragraph 21, please. Bottom. Court there characterising first question before it as whether the then Sixth VAT Directive precluded national legislation under which the right to deduct could be refused to those in possession of incomplete invoices, which were then supplemented by information seeking to prove effectively the charge to VAT.
I noticed from the beginning of the judgment that they give judgment without asking for an Advocate General's opinion, which usually means that they think the answer's obvious and doesn't break any new ground.
Yes, my lord, so they're applying established principle in their own view. The answers are then given, if I can ask my lord to go to page 120, paragraph 34. Firstly, common system of VAT does not prohibit the correction of incorrect invoices. So when all of the material conditions required to benefit from the right are satisfied, and before the tax authorities made a decision, the taxable person submitted a corrected invoice, can't in principle refuse the right. Thereafter, the court drew an important distinction. Paragraph 35, because in this case the information necessary to complete and regularise the invoices was submitted after the decision to deny the right to deduct. The court said at H there, with the result that before the decision was adopted, the invoices provided to that authority had not yet been rectified to enable it to ensure the correct collection of the VAT and to permit supervision thereof. An echo of what was said in Reisdorf about one of the purposes of the VAT system. And therefore, paragraph 36, that type of legislation was not precluded. And so in my submission, Petroma is authority firstly for the proposition that even where the information necessary to regularise an invalid VAT invoice is provided, if that occurs after the tax authority has decided to refuse the right to deduct, then it can still be refused. The second proposition I draw from Petroma is that material provided to the tax authority after the decision has been taken to refuse the right to deduct can be disregarded. And they're both on the same grounds as set out by the court at 35, because the taxpayer has not, before the decisions made, enabled the tax authority to ensure the correct collection of VAT and permit supervision thereof. Both those propositions in my submission must apply a fortiori where the tax authority has required the production of the original VAT invoice as a condition of crediting or repaying the input tax, and the taxpayer has simply not provided them at all. And so applying the logic of Petroma, once this appellant had failed to comply with the requirement to produce the invoices, and HMRC had made the decision refusing the right to deduct, any later provision of valid invoices, either to HMRC or the FTT, is not relevant. As my lord will recall from Scandico, the Upper Tribunal there applied Petroma in concluding that the Upper Tribunal's jurisdiction on appeals concerning the Regulation 29(2) discretion was supervisory only. The instant Upper Tribunal, of course, relied on Petroma also, paragraphs 105 to 108, to reach the same conclusion, and in my submission it was correct to do so. Can I then go to Cohenzad, please, my lord?
To what?
Cohenzad.
Where's that?
That should be in my lord's volume 1, tab 10, page 152.
152,
my lord, forgive me.
yeah.
Judgment of Mr. Justice Sheeman, as he then was, in my submission, persuasive authority to the same effect as Petroma, but here viewed through the lens of the exercise of public law discretions. And this case has been applied consistently for the last 30 years. Until today, I'm not aware of submissions being made to the effect that it's wrong. And whilst the precise details are not the same, the basic facts are on all fours with this case. The appellant in Cohenzad claimed that at the time of exercising the right to deduct that he held the invoices. He said he couldn't produce them in that instance because he said the commissioners had taken them. So no invoices were ultimately provided at all. And as my lord has noted already, in the absence of either any VAT invoices or any alternative evidence, HMRC made Section 73 VAT assessments. I ask my lords to go to page 153, please.
Yeah.
At G, his lordship began dealing with the important issue of jurisdiction. And over the page at 969 D to F, my Lord Justice Lewison has already noted, his lordship envisaged that both the appeal limbs, gateways, were engaged. Under E, noting that it was well established that the tribunal, when considering a case where the commissioners have a discretion, exercises a supervisory jurisdiction, not original. Not only that, been recently decided that it's to be exercised in relation to materials which were before the commissioners, rather than in relation to later material. The last case his lordship relied on was the decision of Mr. Justice Dyson, as he then was in Peachtree. Just for completeness, my lord, that was a discretionary decision to impose a security requirement for VAT. So it's under the same paragraphs as we're dealing with here. It's also a para 4 power of the revenue. And Mr. Justice Dyson confirmed, as Mr. Justice Sheeman said, what the position was.
Sorry, I'm being a bit slow.
Forgive me.
If you go back to 154,
Yes, my lord.
so this is a case where there was an assessment.
Yeah.
And are the provisions that he's referring to there what's now become 83 of
Yes.
the Act?
So they
And
are.
I'm just looking at the wording. So M is P.
Yeah.
Yeah.
Yeah,
C
sorry.
is still the same. Forgive me. So those are the antecedent provisions. And then goes to page 155, please. J. His lordship set out the tribunal's approach, which was to ask whether in the absence of any tax invoices establishing inputs for the relevant periods, any and if so, what inputs might be allowable. And then at the top of the next page at A, tribunal asked itself whether the commissioners, in refusing to allow the appellant to deduct input tax, had acted in such a manner that no reasonable commissioners could have acted, so the test. And that's upheld as being the correct approach. They asked, in substance, the right question. There wasn't a wrongful exercise of the discretion. And then at F, please, at the bottom of the same page, the fact that the appellant now says he has, and for all I know does have, copy invoices which bite on this matter, is not something which will lead this court to quash any of the decisions, because the material was not before the bodies making the decision. And so Cotton's is, in my submission, to the same effect as Petroma, but just via a different route. So when one looks at the paragraph 4.1 Schedule 11 VAT power, it's a discretionary power. Commissioners may, as a condition of allowing or repaying, require the production of such evidence relating to VAT as they may specify. Since that is in itself the exercise of a discretionary power, as is well established, my submission is that jurisdiction on an appeal against that as the underlying decision could only be supervisory, by submitting that either the requirement itself was unreasonable or the conditions themselves set were unreasonable.
Yeah. So just pick up one of Mr. Morse's points, it would be open, at least in theory, for the taxable person to say, well, we offered an inspection to HMRC, they turned it down, that was unreasonable.
Yes.
And therefore their exercise of discretion is vitiated.
Yes. So as the Upper Tribunal envisaged right at the end of its judgment, within the jurisdiction of Reg 89.2, Paragraph 124, the Upper Tribunal said, we observed that in exercising its statutory jurisdiction, the FTT is well able to decide whether or not the HMRC officer acted unreasonably.
Yeah.
For instance, by requesting information which was irrelevant or by refusing to accept an invoice was valid. So that encompasses the type of action that my Lord has raised. Still perfectly within the supervisory jurisdiction. So, secondly, once the tax authorities required the original VAT invoices, they haven't been provided. The tax authorities refused the right to deduct. On Mr. Justice Sheeman's understanding, it's the same as Petroma, they're not to be taken into account because they're not before the decision maker. And whilst we're in the authority, it tends against my learned friend's submissions that the Regulation 29.2 discretions simply aren't engaged where someone says, I hold the invoice. That's just what happened in Cohenzad.
Well, I think he was saying, wasn't he, that the revenue had actually seized the invoices.
He was saying they'd seized them, but then his second.
So sorry, they'd seized the original one.
Yes. And then he said.
But then he said, I've got copies.
Yeah. So his suggestion was he actually held them at the time of exercising the right, but hasn't produced them. That's the same factual circumstances broadly as there are here. Cohenzad's been taken to be the correct approach for the last 30 years. The second authority I relied on was Boyce, and it's to the same effect. I'll simply give my Lord the reference if I might. It's paragraph 14 at page 406, which is Mr. Justice Arnold following Cohenzad, so perhaps doesn't add more than that.
Well, there have been lots of cases that have followed Cohenzad, but there's no decision of this court, is there, that specifically approves it. I think it was common ground in Tower Bridge.
It was.
So that the jurisdiction was supervisory.
It was, my Lord.
So certainly as a matter of precedent, it's open to Mr. Morse to say that
Absolutely.
Cohenzad is wrong.
And I put it no more than it's highly persuasive.
Yeah.
Doesn't bind this court. Cohenzad was also considered in the next authority that I rely on, which is Scandico. Can I take my lords to that briefly, please? That is in your second authorities bundle, tab 23, beginning at page 410. My lord, know the background to that. One piece of background to fill in pieces of the puzzle, my lord. Page 413, please. Paragraph 3, in relation to whether there were assessments. So there weren't in that case.
There weren't.
There weren't.
Right.
So that was an extended verification.
Oh, okay.
HMRC hold the input tax, and then they refused it to credit it or repay it by those decisions.
Yeah.
And goes over to page 416, please. Paragraph 17. Lady Justice Rose, as she then was, and Judge Hillier described the discretion in Regulation 29 as being one to direct that a deduction can be made in the absence of a VAT invoice. The same language used as in Cohenzad. And then they went on to characterise the decision made, which is page 421, please. Paragraph 39 at D. In the absence of VAT invoices, there was not enough information provided for HMRC to decide whether there's been a taxable supply or not. It's the same has happened here.
And your submission, as I understand it, is that it doesn't actually matter whether that decision is reached by under 29 on its own, or whether it's a combination of 29 plus para 4 of Schedule 11.
Or plus anything else. So ultimately it's going to end up in a decision refusing input tax. And it might be, as in Scandico, you don't have to issue a VAT assessment. You might say, we the revenue have been holding on to the money. We can't issue an assessment because nothing's due from you. We're just going to deny you. We're into section 83 1C as an appeal gateway. My learned friends say there, well, that's fine, that's a supervisory jurisdiction. But somehow, if you issue an assessment, you're under 83 1P and that jurisdiction explodes into a full appellate one, despite the fact that the underlying decision is exactly the same. And indeed, you might have cases where there's a mixture. We say this is one of them, but certainly conceptually, you may have ones where the revenue have not caught up in time. MTIC type case where they have to assess for some periods, but they're already verifying other periods. And you'd have a mixture of assessments and denials. And then apparently the FTT is in the position where it's applying different jurisdictions on the same underlying question simply because of the liability notification mechanism. A similar argument was made in Scandico, my lord. Paragraph 41. My lord's already adverted to it. But the suggestion there was, by Mr. Pickup, King's Counsel, because I'm bringing my appeal under 83 1C, it's the amount of input tax, and I can therefore argue effectively anything as to that. And that was rejected. At H. 3 lines down, the fact that the challenge to both kinds of decision comes to the tribunal through section 83 1C VATA does not expand the jurisdiction. And so it is in my submission with assessment. So over the page, please, my lord, page 422. Paragraph 43, the Upper Tribunal said in appeals of this kind, the FTT should address only the decision which is before it, and the test is Cotton's Ad. So this is contrary to my learned friend's approach, which is it's the gateway that drives the jurisdiction. Scandico analysis, which in my submission is correct, is the decision drives the jurisdiction. If it were otherwise, then in any case where there's a Section 73 assessment, even if the sole issue is the exercise of the discretions under Regulation 29(2), the ordinary public law principles of a challenge to that discretion are simply thrown out of the window by the appeal gateway. And there is no purposive interpretation of Section 83 that in my submission is intended to produce those kind of results. It's providing gateways for a vast variety of decisions made by HMRC, be they about zero rating, liabilities of all sorts, whether someone should have been registered, and if so, how much they're asked to pay. It's the decision that drives the jurisdiction, and that's the effect of Scandico that in my submission is correct.
Can it matter whether, in broad figures, you owe us or we owe you?
No. It's a matter of absolute happenstance, my lord. So the same with whether it's an input tax denial that needs an assessment or not. It's just what the figures turn out to be for any given period. And if the taxpayers are now to be told it does matter, It's very easy to simply ensure that your returns produce that result. And so you can effectively buy an appellate jurisdiction of the tribunal through the way you choose to fill in your VAT return. That, in my submission, is not likely to be a rational analysis. In Scandico, the tribunal also considered Petroma. Before they did, just on that same page, please, at 44. The last sentence there. The task of the tribunal is not to fill in the gaps or complete the picture in order to come to a conclusion for the first time as to whether all the substantive requirements for deduction are met. Then considered Petroma, which is at page 425, please, right at the bottom. Then at the bottom of 426, what Petroma was authority for. And that's a proposition that I've drawn from Petroma.
Yes.
And so in my submission, Scandico is persuasive, again only persuasive, authority for the following propositions. Firstly, where HMRC's decided that in the absence of valid VAT invoices, it won't exercise the Reg 29.2 discretion. That is the only decision that the FTT should address on an appeal. Secondly, it's not the task of the FTT to conclude for the first time whether all the substantive requirements are met. And thirdly, based on Petroma, where HMRC refuses the right to deduct because the information provided is incomplete or irregular, the FTT should not permit that discretion to be sidestepped by producing information that was not before HMRC. The Upper Tribunal here, my Lord, of course, drew assistance from Scandico, paragraph 104, making the point that this is effectively the same case in terms of the position. And in my submission was correct to do so. So applying the logic of Scandico here, my Lord, it's that the taxpayer cannot, on an appeal, seek to sidestep, firstly, HMRC's requirement that the valid VAT invoices are produced. As a condition of allowing the input tax claim. And secondly, sidestep HMRC's Regulation 29.2 discretion by seeking to establish ab initio that it was permitted to exercise the right to deduct. And as I've already submitted, Scandico also establishes that it's the decision that is the driver of jurisdiction. So the position emerging from those authorities in my submission is clear. Where HMRC's required the production of the invoices as a discretionary condition, and that's not done for whatever reason, the appeal is on a supervisory jurisdiction.
And that's your propositions 3 and 4, I think.
Effectively, yes, my Lord.
Right.
And that, of course, in my submission reflects the ordinary position in public law. It's exceptional to permit a public law decision to be impugned by reference to material that was not before the decision maker. And my Lord will have seen in the skeleton argument the implications of it in terms of the operation of the VAT system that the Upper Tribunal agreed with, albeit they didn't rely on it for their submissions.
Yeah. Of course, in Housley, it worked in the taxable person's favour, because the HMRC weren't given the opportunity to justify their decision by reference to material they hadn't considered.
And that's a problem with my learned friend's construction in my submission, because if one looks at para 4.1, Schedule 11, my learned friend's right, and I'm right, on jurisdiction, and the taxpayer doesn't produce the invoices, there is no Regulation 29(2) discretion. That's the effect of my learned friend's case. HMRC's case is it always applies in the absence of valid VAT invoices, i.e. this is a safety valve for taxpayers who, for whatever reason, have not produced the valid VAT invoices.
Yeah.
If my learned friends are right, it actually functions. The revenue can impose that condition and then effectively pull the shutters down. So it imposes, by default, a no invoice, no deduction regime. The very opposite of what the provision is meant to achieve. So that is the third submission, my lord, that it's the discretions are engaged whenever the requirement to produce the valid VAT invoices is not complied with. Firstly, because of the practicalities of that approach, and that is that HMRC as the decision maker, the position before them is identical. Whatever the reasons, the actual base analysis is valid VAT invoices have not been provided for us, even though they've been asked for. As soon as one frames the issue instead by reference to what the taxpayer has said, it holds. In my submission, that creates numerous difficulties and uncertainties. The taxpayer might not answer at all. HMRC say, you produce your invoices, please. There's no response. 6 months later, I'm going to deny you. Later on, they say, well, I held the invoices. Are we then to go to the FTT to prove that the invoices were held? But what if the FTT concludes they weren't? You, the taxpayer, haven't established that you held them. Is HMRC then to exercise the Regulation 29(2) discretions? If so, on what material? The material that was wholly non-existent before the FTT? Or what was produced in the FTT? Or perhaps something after the FTT? There's all these difficulties thrown up by the appellant's construction that on HMRC simply don't exist, which is everyone has the certainty that whenever valid VAT invoices are not produced, HMRC accept that the discretions are engaged. And one avoids then those messy, protracted disputes and the answers to those questions. In my submission, that better reflects what was said in Reisdorf, but it also reflects, importantly, the structure of Regulation 29(2) itself. So can we turn to that briefly, please, my lord? My lords, have that in the first volume of authorities, tab 2, page 36. So there is the first part of Regulation 29(2) at the time of claiming deduction of input tax, and then there's the various requirements depending on what the claim is in respect of. But the tailpiece provision, page 37, provided that where, etc. But the first point is those discretions are not on their face fettered to apply only in a particular set of circumstances, only at a particular fixed point in time. They are not only as to what can be held, but also what should be provided. And where they are on their face unfettered, my lord, in my submission, just applying the ordinary principles of public law, it's not for HMRC to seek to exclude as an entire class types of factual circumstances in which the revenue would consider exercising the discretion.
Could they not? I mean, of course, when there's an apparently unfettered discretion, I would accept that, but the proviso is that the commissioners can give direction in relation to particular cases or classes of case. Could they
Yes.
not say, in this class of case, we will require A, B, C, and D, and in this class of case, we will require D, E, F, and G?
One could, as long as it doesn't go against the purpose of the discretion, which is to act as that safety valve.
Yes.
And so, yes, one can direct in relation to particular cases or classes of cases. It's likely to be directed at particular methods of trading or types of liability. But to simply say we're not going to consider it at all where you don't produce a valid VAT invoice to us would be contrary to that purpose. And so that would, in my submission, be a fetter. And of course, this does not exist in a vacuum. This piece of secondary legislation has to coexist with the power in paragraph 4.1 of Schedule 11 to VATA. And
as I understand your submission on the first point there, you're saying if you read this naturally, it's not actually saying, it's not sort of proviso in the way that you sometimes see in contracts where it's, as it were, an exception to what's gone on before. What it's actually saying is the taxpayer must do certain things, but the revenue can, in the exercise of its discretion, allow other things.
yes, or require other things.
On that, or require other things. But on that reading, it's not as it were a precondition to the exercise of the discretion that in this case, that the taxpayer doesn't hold the invoices. It's just saying that the taxpayer must hold them, but in any event, the revenue can accept other evidence.
Yes, my lord. That's the reading that I invite the court to adopt, because there is no bright line drawn between 2 A, B, C, D, E, and F and the broad tailpiece. It doesn't say if you don't comply with A, B, C, D, E, or F, the commissioners can do this. Nor could it, because it includes a provision that you must provide something which is beyond what is in A, B, C, D, E, or F.
Yeah.
And so it's a much broader discretion afforded to the revenue. It operates both ways, as my Lord Justice Jackson has alluded to. It's protective of the revenue, they can require more. It's also protective of the taxpayer who can't do what's required in A to F, because the revenue have the discretion. And so it does apply.
I'm slightly puzzled by that submission, I have to say, that it could be, as it were, favour the revenue by, so that if, for example, someone did hold the invoice, nonetheless, under this provision, something more favourable to the revenue could be done.
No, it's so in terms of establishing things, for example, like, have you paid the consideration? You may have produced an invoice which gives you the right to exercise the right to deduct. If you haven't paid the consideration within 6 months, for example, then the right to deduct effectively disappears. And so there are all...
But this seems to be, I'm sorry to interrupt you, but this seems to be saying that the revenue can call for other evidence, in other words, as an alternative to those things. I accept that there are other provisions which, in particular paragraph 4, which says the revenue can pull for information more generally of the kind that it needs, it says that it requires. But this provision does seem to be a broadening to me rather than a narrowing provision.
It is a broadening, but it is also reflective in my submission of para 4.1, because it refers to provision of information rather than simply holding. And so it goes beyond what the earlier parts of the regulation envisage, and they have to be considered in my submission in a way that makes a coherent whole scheme. So, for example, where the revenue exercise the power in 4.1, what they then do with Regulation 29 if it's not complied with for whatever reason. So the revenue may say we want you to produce the invoices. There may be a suspicion, for example, that although the invoices are produced, no money changes hands, for example, and therefore further inquiries are made. That's included within the broad, you also need to provide this, whether one looks at it in terms of the statutory power or the discretion. So there are elements of it in my submission that may cut both ways, but that's not determinative in this appeal, in my submission. And so my submission is whenever the VAT invoices are not provided, the discretions are engaged and HMRC have to consider exercising them. And as my Lord Justice Lewison's adverted to, when you don't, you're under the peril of the ordinary public law intervention, which is you failed to consider exercising your discretion, which is Housley. And then if there was an assessment, in that case, the assessment is discharged because the original exercise of the discretion can't be maintained. That's the effect of this court's decision in Housley. The fourth submission my Lord has, which is not disputed. And then the fifth submission is effectively whether it matters that there's a recovery assessment. In this case, there is a mixture in my submission. I think a document that you weren't shown very briefly in the supplementary bundle at page 81. My Lord should have their 6th of February 2019 document in relation to VAT period 0818. Headed reduction to amount claimed on VAT return and notice of VAT assessment. So originally the figure in box 5 at the bottom was the taxpayer seeking a repayment of 62,000 odd. That return was adjusted because it hadn't been credited or paid. One can see the adjusted amount of the input tax at box 4 reduced by the 1,354,000 odd. And so the part of the denial that claimed the repayment, one didn't need an assessment for. One just needed to deny it, and then one assessed on top for whatever else. So this is an example of a mixed decision where 83.1c as an appeal gateway and 83.1p must be in place.
So let me just try and get my head around this. Box 1 is the output tax.
Yes.
And that's then carried into box 3.
Yes.
Box 4 is the input tax.
Yes.
I see. So the effect of the return was that the input tax reclaimed exceeded the output tax due.
Yes.
So the net VAT was a credit balance in the taxable person's favour.
On the return, yes.
On return. Following the adjustment, the output tax goes up.
Yes.
The input tax comes down.
Yes.
And we now have 2.9 million debit to the taxable person.
2.9 million owing to the revenue.
Yeah.
Yeah.
So the 62 is HMRC owes the taxable person, and the 2.9 million is the other way around, taxable person.
So the 62,000 doesn't have to be assessed for. It's just denied, which is why it's described as reduction to amount claimed on VAT return and notice of VAT assessment.
So should there be a minus in box 5 beside the 60?
Yes, it's unhelpful.
Well,
it should have been a minus 62 as what was sought. And there's an explanation in the review letter setting those out, which is at page 90 of the same bundle. paragraphs just above legislation set out what's happened with the 0818 and 1118 returns. So they make it plain that there's been a denial under section 25 and an assessment for the other part of the sum. So on my learned friend's case, when we get to the tribunal, it will be considering
two different bits under two different jurisdictions.
Yeah. From precisely the same VAT period, simply by the figures. So as I've submitted, my lord, the gateways in 83(1) C and P are just that. And the general jurisdiction under either is appellate. It must be to cater for the broad variety of decisions that may come through them, but it doesn't mean that the tribunal's jurisdiction on the particular decision is supervisory. There's a similar argument in Scandico, which my lord has seen, that was rejected. None of the authorities that my learned friend Mr. Morse took the court to are authority for the proposition that when one's looking at a Regulation 29(2) decision and an assessment, it's appellate. They've only ever considered the matter broadly, noting that for 83(1)P, it's appellate.
What do you say about Pegasus Birds?
The Pegasus Birds is concerned with best judgment, but even on best judgment, it's not fully appellate. The summary in Roscoe Noonan you were shown in my submission is absolutely correct. The first step is, has it been made to best judgment? That's a supervisory jurisdiction.
Yeah, but that doesn't preclude an appellate jurisdiction over the amount of the assessment, according to...
That's the second step, the quantum.
Yes.
Yes, and in my submission that's right. Quantum is always a full appellate jurisdiction. So
why is it not open to someone who wishes to challenge an HMRC exercise of discretion under Regulation 29 to say, well, insofar as you exercise the discretion, I accept that's supervisory, but insofar as you disallowed a particular amount, that's wrong. And I can appeal against the amount you disallowed or the amount you assessed.
Because all of it is part of the same decision, so it's all the Regulation 29(2) decision.
So wouldn't that be the same for a best judgment assessment? It's all the same decision under Section 73.
Well, there would be two issues in relation to best judgment. The first is whether it was to best judgment at all, and the second is whether the taxpayer can establish that in fact the quantum is wrong.
Yes, I follow that. What I'm trying to tease out is what you say the distinction is between that kind of case and this kind of case where the taxable person says you have disallowed too much.
It rather, in my submission, depends on what the too much argument is. So you might have the too much argument, I want to produce all the VAT invoices.
Yeah.
Which would be to sidestep the discretion and put material before the court that was not there. Or you might say, I accept I can't produce all the VAT invoices, but even on your own figures, for example, in this case, it's not £34 million, it's 15 million or whatever in terms of the alternative assessments. So there's two ways in which you might approach quantum. When it's a Regulation 29(2) discretionary decision, in my submission, you can't attack quantum by producing invoices claiming they're valid and that you therefore can exercise the discretion as of right. You might produce them to say, actually the figures on which you assessed lead to a wrong overall result. So that is the distinction.
Wait a minute. Well, once you accept that VAT invoices can be produced in order to challenge the figure, aren't you straying beyond a supervisory jurisdiction into an appellate jurisdiction, because on that analogy or that hypothesis, the taxable person could say, well, you have disallowed £100,000 worth of input tax, which I claimed in my return. That's too much, because look, here are invoices for 50,000. Now, is that precluded? Under a supervisory jurisdiction, unless those invoices had been produced or at any rate made available to the decision maker before the decision was made, they would not be relevant to whether the decision was valid or not.
No.
But if you accept that on a quantum challenge, the taxable person can say you shouldn't have disallowed £100,000 worth of input tax because here are invoices for 50,000, then you are into a different kind of jurisdiction in which evidence that wasn't before the commissioners when they made their decision can be placed before the FTT.
So in my submission, it depends on the purpose for which they're being produced to the tribunal. So if the purpose for the production is to say these were valid VAT invoices and therefore you must permit me the right to deduction, that in my submission is not permitted. So that's squarely within the supervisory jurisdiction. If there's some other issue as to quantum,
is that right?
yes, because it would be trying to put before the tribunal invoices to say these were valid VAT invoices that were never put before the decision maker.
Well,
and sidestep the whole discretion.
let's suppose that the HMRC said, I don't know whether this is correct or not, if the consideration for the supply is expressed in euro, we do not regard that as a valid VAT invoice. So you produced all these euro invoices to us. We disagree that these are not valid. We are not going to allow the input tax. And the issue is an invoice where the consideration is expressed in euro a valid invoice, valid VAT invoice or not? Is that purely supervisory, or can the taxpayer go to the tribunal and say, look, this is a point of law. The revenue has got this one wrong. It's a perfectly valid invoice.
But that would be still within the supervisory jurisdiction. So it's because the officer has irrationally,
it would include an error of law.
Yeah. So the officer has irrationally concluded this VAT invoice required a certain currency when in fact the law doesn't. So it'd be a classic error on the face of the decision, still impugnable in the supervisory jurisdiction. And so that's that example. The quantum issue is external to the purpose for which they're being produced almost. It must be that you say, so in this instance, HMRC denied, I think, 90% or 95% on a best judgment basis. It should be open for a taxpayer to say, these were overheads. These were outside the 1,000 that you asked for in terms of the limit of VAT. What you've done is not given me sufficient overheads. You should be able to challenge things like that. What you can't do is use that as a gateway to sidestep the Regulation 29(2) discretion. So I accept that that quantum must be appellate in some form, just as it is in best judgment, but it can't be used as a gateway through which to produce invoices that were never before the revenue when the decision was made, and effectively to sidestep both the requirement for production of the invoices and the Regulation 29(2) discretion.
Is it a peculiarity of this case that the assessment at 34 million was just an error?
It's not that it's expressed in a figure that's an error, my lord, because there are alternative assessments. One on the basis.
But it seems like, I mean, in a sense, it seems like a sort of schoolchild error. I mean, you had two alternative bases for assessment, and you just added them together.
Yes, it's accepted that is not.
But I mean, while we're looking at all of this minutiae, I mean, if we look at the actual bill, it's sort of wildly over the top.
It's accepted that the 34 million is not cumulative. They shouldn't be added together.
But that question, that sort of question, could obviously, if the revenue was pressing for 34 million, that sort of question could obviously be
within quantum.
or appealed, whatever the
Yeah.
whether you call it a supervisory or a full appeal.
Exactly, and so I'd submitted to my lord that that is exactly the type of thing where you would say, well, there must be some element of quantum that's appellate, because even looking at this, the quantum is, and it's accepted between the parties, is misstated.
What is the situation if somebody says, I'm not going to allow you your tax because you didn't send us invoices? To which your reply is, yes, look in your inbox and you will see that I sent you invoices for this period.
Well, then
And you still go ahead and make the assessment. As if they hadn't put in invoices. Where does that fall?
So the officer would doubtless be challenged on the rationality and best judgment of making the assessment when it was proved that he'd been sent the invoices. So it shouldn't be thought in my submission that the supervisory jurisdiction is peculiarly limited in some way. It encompasses the rationality of what's done with the discretions. So ignoring things that are sent to you, for example, making unreasonable demands. If indeed you've acted with such irrational haste that the discretion is impugned on the ordinary spectrum of public law grounds, that is ample protection for the taxpayer. The alternative is question of jurisdiction becomes driven by happenstance. The precise liability notification method wags the dog in terms of the question of substance. And it just becomes another way to sidestep the discretions. So whilst under section 70, under 83(1)P or 1C, those are broadly appellate gateways, where what is impugned is the decision under regulation 29(2), the discretion is supervisory. There may be other elements. You may say there's also a best judgment challenge. That's to a separate issue, my submission. And in this case, there is no best judgment challenge. Can I take my lord to the grounds of appeal as they are? Those are in my lord's supplementary bundle, tab 8, page 65. First point, my lord, is ground 1, paragraph 1, stated to be an appeal against the decision made on the 7th of January 2019. That's not the decision to assess. That's the letter that says, I'm going to deny you your input tax. And that is the decision over the next page at 8 that the appellant wants quashed. But there's no reference to the concept of best judgment. The requirement in Pegasus Birds is if you're going to make a best judgment challenge, you set out what it is, especially if it's going to involve any form of
I may be going back over old ground, but when Mr. Brown was addressing us, in response to questions from my Lord Justice Peter Jackson, he said that the appeal is actually an appeal against the review decision, that being the decision of the commissioners. That review decision is the 7th of June 2019. The appeal appears to be against Officer Mill's decision earlier in the year, not against the review decision. Do you want to say anything about what it is that the taxable person ought to be appealing against.
Well, there's been a debate as to whether one is technically appealing a review decision or an original decision. In many cases, and often it will just resolve to what the grounds of appeal themselves actually say.
Mm.
And these grounds of appeal attack Mr. Mills's decision.
Yeah.
And that is what's been done. I can't really submit any more than that in terms of
but that's perfectly permissible.
or should be done. Yes.
You could do it either way.
Yes, effectively. You can say, in this case, because the review decision upheld, that's how it's stated.
If they're the same, then it
Yeah.
probably doesn't matter.
No.
If it had been different,
If it was different,
then you'd be looking at the review decision.
exactly.
If that's
So,
what,
so my lord, you might have a case where the review officer has said, actually, this part is out of time, or I need to reduce the quantum, or what have you, and then that becomes the decision appeal against, where it's just upholding the original decision. It's effectively one and the same, which doubtless is why the grounds of appeal are drafted as they are,
Yeah.
and there is no best judgment challenge within them, and the position currently is there's no challenge within them that the appellant even held the VAT invoices, and this court's already refused permission to argue an appeal on that. And so the best judgment type issues that my learned friends has alluded to in my submission simply aren't within the scope of the grounds of appeal, but that's perhaps for another day. My lord, might I turn my back briefly? Unless there's anything else, my lords, those are my submissions.
Thank you. Now, who's going to reply for the appellant? Are you both going to reply?
I think probably somebody. I'll take the lead, my lord, if I may,
Right.
initially. And I'm only going to make a few short points. In respect of section 29.2, and if I'm repeating myself and you already have the submission, please.
Do you mean regulation?
Sorry,
Do you mean regulation?
sorry, I do mean regulation. Thank you, my lords. That was it. Paragraph 30, page 36 of the authority.
Yeah.
Been to it several times before. But this was obviously what was considered, although it was in a previous form in Cohen's Act. And it is the tailpiece with which we have been concerned. And my submission has been and still remains that the discretion only kicks in, the discretion being to the commissioners to require such other evidence, i.e. in addition to or as an alternative to the invalid VAT invoice. Or, sorry, a valid VAT invoice, I do beg your pardon. Because as we know, at the time of claiming the deduction, the person shall hold that document. And therefore it's implicit that if the commissioners do exercise their discretion, they must have decided, as the appellant says in this case, that it did not hold a valid VAT invoice. That's the only time the discretion can kick in. So
What if they have reason to believe that there is no?
Well, that's
valid
a decision, my lord. That is a decision of the commissioners. You don't have a valid VAT invoice, and therefore we are potentially exercising our discretion to allow you to provide or hold other such evidence.
And what if they don't know? Because they've asked for it, and for some reason the taxpayer has not provided it. In those circumstances, couldn't the revenue say, well, we don't know whether you've got this or not, but we're prepared to accept some other document?
But that only kicks in if you do not, the taxpayer doesn't hold a valid VAT invoice.
Well, why is that necessary as a matter of language? It says that the taxpayer must do that, but it also says that the commissioners may, because it's a discretion, direct that the claimant shall hold or provide other evidence.
Yeah.
But why does that only arise where, as a matter of fact, the taxpayer does not hold the...
If I can invite your
invoice?
lordship to go to Cohen's-Ad, so that's page 154.
Well, is it possible to answer it by reference to the wording?
Well, this is exactly what was discussed in Cohen's-Ad. If I might just, so page 154 of the authorities bundle, just below A, where the court has set out what is now regulation 29. So A, now the effect of those provisions is that prima facie a registered taxable person is not entitled to any credit in respect of input tax unless at the time of claiming such a credit he holds a tax invoice in relation to that supply. And the commissioners, as is well known, will from time to time send somebody to look at these invoices to see they add up. But nonetheless, the second effect of the provision is that the commissioners have a discretion to allow credit for input tax, notwithstanding that the registered taxable person does not hold such an invoice.
I don't think that really answers my question.
Doesn't it? I do beg your pardon, my lord. Would you...
Supposing that the...
Sure it's me.
I mean, that's clearly one situation.
Yes.
So there's a discretion even if they do not, as a matter of fact, hold
Yes.
the invoice. What I'm really getting at is this. Supposing that the revenue has asked for an invoice and the taxpayer is just not responding.
Yes.
The revenue doesn't know for sure whether there's an invoice or not.
Yes.
But it says, well, in any case, we'll accept some other evidence. Is that not within its power under...
It is. It is within the power. I accept.
Right, and then it turns out, as a matter of fact, that the taxpayer, rather against the odds, does in fact hold the invoice.
Yes. But then again, I don't dispute the commissioners have the power to deny input tax if they are not satisfied. But the point is, just getting back to why we are here, is it an appellate matter where the appellant says, I had those invoices. I accept the commissioners didn't see them. I made them available by inviting the commissioners to come and see them. But nevertheless, I've lost my train of thought, I do beg your pardon. Nevertheless, the fact that I held the invoice allowed me to exercise that right. And the commissioners are now denying me that right. Therefore, whether I actually held the invoice or not is an appellate matter. If, then as it has done before in the First-tier Tribunal, the First-tier Tribunal decided, no, that actually wasn't a valid VAT invoice, I'm sorry, then the supervisory jurisdiction comes into play as to whether the commissioners were right or not. I know I've said that several times before, and I don't wish to, if I don't say it again. So therefore, if I might just move on very briefly to the cases that my learned friend cited, particularly Scandico, I've taken you to that before.
Yeah.
My learned friend says, well, they are the same case, effectively. My submission as it was, they are not the same case. Mm-hmm. Those till receipts were put before the commissioners, and therefore the commissioners decided they are not valid VAT invoices. And therefore the appeal was against the exercise of discretion only in that case. Scandico tried to open it up to say, well, the tribunal can decide whether an actual supply was made or not. But that was the decision of the commissioners. You haven't got a valid VAT invoice. We're not accepting that or anything else as alternative evidence. that was the decision. In this case, we say, well, the commissioners did decide, as per the review letter, we say you do not hold a valid VAT invoice.
Why is it so different from verity? You know, that there was, as I understand it, your client said, well, here is some proof, and that included a number of bundled invoices.
A sample of invoices is the way it was put.
Sorry?
A sample of invoices.
No, but also they produced documents which referred to either Verity or Verity Limited. I don't know whether it's Mr. Mills who assumed it was Verity Limited.
Right.
But Verity was said to be a code.
Yes, that's correct. It was
Right.
the way it was reported in the business records, whereas in fact it was many suppliers.
Yes,
under
so it was
this-
a it was, on your case, it was a bundled group of
Yes.
suppliers.
Yes.
But I mean, what's the conceptual difference between Verity and an invoice from the Apple store?
There was never any documentation and would never in the name of Verity.
Yes, but you produced a certain proof, as you saw it, that the money had, you'd expended it.
Yes, there was a.
And
yes.
I mean, it's rather like an invalid
Well,
invoice.
that's going to be the matter for factually, a matter of fact before the
So
tribunal.
I'm only saying when
Because
you're saying, well, Scandico is very different. I'm just wondering whether it really is very different.
Oh, I see what you're saying.
Yes.
Sorry. Well, but in Scandico, it was agreed by both parties that they could never be valid VAT invoices.
Well, nor could Verity.
No,
I mean, whatever they are as proof, they're not a VAT invoice.
no. I think that perhaps there's been a bit of a misunderstanding, my lord, that the appellant says the documents it provided to Mr. Mills, and bear in mind Mr. Mills says in his decision letter, I've seen no evidence. So that's going to be a matter of fact as to what was sent and what was received. But the sample invoices that would be sent, the appellant says, were valid VAT invoices, not anything represented in the name of Verity. Thank you. Just very briefly, before you need to hear from Mr. Morse if you need to. Very briefly on Petroma. My learned friend says anything provided after a decision on a supervisory basis, it can still be refused. That's correct in relation to that appeal. But Peachtree tells us, and it's not in the authorities, and I apologise for that, that if further evidence is supplied after a decision is made, then the commissioners should make a new decision. That's what Peachtree says. Which makes perfect sense. You can't just have a one-shot go and then that's the end of it. You should be entitled to provide further evidence post-decision, and then the commissioners make a decision on that new evidence as a totality.
Yes, but that would be a completely different point.
It is. I'm just trying to say, my lord, just to clarify, I accept on a supervisory jurisdiction, then it is the evidence provided at the time. I don't think I need to say anything else.
Right. Thank you. Mr. Morse?
Thank you, my lord. Very briefly, just 2 points. Grounds of appeal. If I could invite you, please, to go back to page 64 on the supplementary bundle. You will there find this is the form that one submits. My lord, it starts at page 63.
Yes.
And also make the submission that one can start an appeal in the First-tier Tribunal without submitting separate grounds. So what's part of the statutory form, if I can use that terminology, is all of the details set out in paragraph and pages 63 and 64.
Yeah.
It's very small print, my lord, but at the very top of page 63, underneath notice of appeal, there's the word generated, and then 24th of June. So the submission is, this is the form as submitted to the FTT.
Yeah.
On page 64, under appeal details, second subheading, desired outcome, the most, I say, straightforward and unequivocal terminology is used. We would like the tribunal to vacate the assessment. So the suggestion that this appeal is not concerned with the assessment is, in my respectful submission, plainly wrong. I submit that's also wrong by reference to the wording of the statement of case. I forget the precise rule, it's either 20 or 21 of the First-tier Tribunal rules. The statement of case is responsive to the appeal that has been made. Forgive me, my lords, the statement of case, tab 27, page 103. I need only to take you to the first two lines of the statement of case. So I'm at supplementary, tab 27, page 103, paragraph 1.1. This appeal concerns the respondent's decision notified to the appellant. My lord, it says to assess it for VAT and interest of 34 million. It does not say this appeal concerns the respondent's decision to deny input tax. So that's the grounds of appeal point. Second point is in relation to the nature of section 83(1)(p). That's actually at authorities page 18. Lord Justice Chadwick told us what that was at page 236. There are two limbs, as I put it, not his lordship's words but mine. The tribunals, the appeal lies in relation to the fact of the assessment, the best judgment point, or the amount of such an assessment. Now, my Lord Justice Lewison, I think, was exploring that to a degree with my learned friend. If my learned friend, Mr. Watkinson, is right, then that statutory jurisdiction is ousted in the absence, in my submission, of clear words to do so. It's plainly wrong to say that on an appeal that engages 83(1)(p), that a taxpayer is not, in particular a tribunal, cannot say, I accept this assessment may have been to best judgment because it's an honest and genuine attempt to get it right. But as my lord was exploring, the amount of the assessment is just plainly wrong. And the tribunal can only do that if it has an appellate jurisdiction. My lords, those are the two brief points I wish to make in reply.
Yeah. Well, thank you all very much for your submissions. Obviously this is a difficult point, particularly since there's a full-scale attack on COINSAD and the cases that have followed it, so it won't surprise you to learn that we will reserve our decision. You will receive a draft judgment or judgments in due course. They come with a fierce embargo, which means what it says, so they can only be shown to those on the distribution list. That will be your opportunity to correct our English but not our reasoning and not to introduce new points. We would hope that in the light of the draft judgments you will be able to agree an order disposing of the appeal, but if no order can be agreed, please make short written submissions and we will make the form of order that we consider to be appropriate. The eventual hand down will be done electronically by email to the parties and released to the National Archives, so there is no need for any further attendance. Thank you all very much.